Before we begin, a quick and important disclaimer. The information provided in this video is strictly for educational and entertainment purposes only. I am not a licensed attorney, a financial advisor, a certified public accountant, or a certified divorce planner. The legal and financial landscape surrounding divorce, asset division, alimony, child support, and economic recessions vary wildly by jurisdiction, state laws, and highly specific individual circumstances. Nothing discussed in this presentation should ever be construed as professional legal, financial, or tax advice. You must conduct your own thorough due diligence and consult with qualified, licensed legal and financial professionals in your specific geographic area before making any decisions regarding your marriage, the protection of your assets, or your overarching legal strategy. Imagine waking up to discover that the very legal system designed to divide your life's assets fairly is about to lock in your absolute financial ruin, simply because of the calendar year you were forced to file for divorce. Historical trends from the 2008 Great Recession show us a terrifying reality that nobody talks about in public until it is far too late to do anything about it. During massive economic downturns, the wealth destruction in a divorce is not just mathematically halved. It is often exponentially magnified by plummeting housing markets, liquidated retirement accounts taken at a massive penalty, and spousal support orders based on a booming economy salary that you simply no longer make. We are looking at historical case studies where men, who were laid off during massive corporate downsizing events, were still ordered by family court judges to pay alimony based on their previous high-earning years. This dynamic trapped them in an inescapable cycle of debt from which they could not mathematically recover. The cold reality is that the courts generally do not care that the stock market just crashed. The legal system does not automatically pause your financial obligations just because your specific industry is experiencing a severe recession. When an economic contraction hits, the divorce rate often spikes initially due to overwhelming financial stress, but then paradoxically dips because couples realize they literally cannot afford to live in two separate households. But for those men forced to navigate the legal system during an active economic contraction, the wealth wipeout is historically unprecedented. You are not just fighting opposing counsel and an adversarial spouse. You are fighting the entire macroeconomic environment. And right now, as inflation continues to bite into daily life and major layoff announcements dominate the financial news cycle, millions of men are walking completely blind into a legal meat grinder. This masterclass is designed to be the ultimate educational resource for understanding the highly complex and dangerous intersection of United States family law and macroeconomics. Today, we are going to unpack the specific, hidden vulnerabilities men face when a marriage dissolves during a U.S. economic recession. By the end of this deep dive, you will understand the historical trends of asset valuation in a down market, how judges typically view temporary unemployment versus permanent career shifts, and the underlying mechanics of protecting your financial future when the broader economy is actively collapsing around you. We will examine detailed case studies of how men have both successfully and unsuccessfully navigated the valuation of rapidly depreciating assets, such as underwater real estate and highly volatile stock portfolios. To truly understand the gravity of this situation, we must first analyze the psychology and the raw data of financial distress within a marriage. Financial friction is historically cited as one of the absolute leading catalysts for divorce in the United States. When a recession looms on the horizon, the immense stress of potential job loss, shrinking emergency savings, and rising costs of living acts as a pressure cooker on any existing marital cracks. But the real structural danger begins when the decision to divorce is finalized exactly as the financial markets bottom out. Let us carefully consider the historical precedent of the 2008 housing crisis. During that specific period, countless men found themselves in situations where the marital home, historically their greatest single asset, was completely underwater. The mortgage owed to the bank was significantly higher than the fair market value of the property. In a standard, healthy economic climate, a home is put on the market, sold, the equity is split, and both parties take their capital to move on and rebuild. But in a severe recession, a forced sale might mean actively splitting a massive debt, or one party being forced by the court to take on an asset that is actively draining their liquid capital every single month. Furthermore, we must address the legal concept of earning capacity versus actual current earnings. This is a critical component that historically destroys men financially during recessions. In the family court system, potential outcomes regarding alimony, also known as spousal maintenance, and child support are very often calculated using historical earning data from previous tax returns. If you spent the last 5 years making $150,000 a year in the tech sector, but a recession-induced layoff forces you to take a survival job making $70,000 a year, the court may still legally impute your income at the higher historical bracket. The underlying legal assumption by the court is often that your sudden drop in income is strictly temporary or worse, completely voluntary to avoid paying support. Overcoming this heavy legal presumption requires a deep, meticulously documented understanding of your specific industry's current macroeconomic conditions. You cannot simply walk into a courtroom, point to the news, and say the economy is bad right now. You must be prepared to present rigorous empirical data showing industry-wide hiring freezes, verifiable sector-wide salary reductions, and localized economic downturns that prove your earning capacity has fundamentally shifted. For men who are entrepreneurs, small business owners, or independent contractors, a recession divorce introduces an entirely different, incredibly volatile layer of complexity. Business valuation during an economic downturn is a highly contested, expensive battleground. Historically, opposing financial experts will intentionally use pre-recession revenue data to artificially inflate the value of the business, arguing to the judge that the current dip in profitability is merely a temporary anomaly, rather than a systemic, long-term economic reality. This aggressive tactic can result in a man being ordered to buy out his spouse's share of the business based on a phantom, high-water mark valuation that simply no longer exists in the real world. To satisfy this inflated cash buyout, the business owner might be forced to liquidate critical operational inventory, take out high-interest commercial loans when lending standards are at their absolute strictest, or even sell the business entirely at a desperate fire sale price. This effectively destroys his primary source of ongoing income, just as he needs it most to survive the recession. The intersection of family law and actual commercial reality is often entirely detached during a financial crisis. This brings us to the division of retirement accounts, another massive, silent hazard during a recession. Imagine a 401k or an IRA that was worth $500,000 just a year ago, but due to a massive market correction, is now worth only $300,000. If a settlement agreement was drafted based on the higher historical valuation, and the actual transfer of funds via a qualified domestic relations order occurs after the market crash, the primary earner might be left with pennies on the dollar while the receiving spouse gets a fixed, disproportionate amount of the remaining liquid capital. The sequence of returns risk, a complex financial concept usually reserved exclusively for retirement planning, becomes a lethal weapon in divorce proceedings during a bear market. Understanding these intricate legal and financial mechanisms is not about exploiting the system. It is about basic survival. It is about recognizing that the legal frameworks governing divorce in the United States were largely built during periods of long economic stability and are incredibly slow, if not entirely unwilling, to adapt to sudden macroeconomic shocks. If you are facing this reality, you are playing a high-stakes game where the rules are rigidly applied regardless of the economic context outside the courtroom doors. This masterclass will systematically dissect these exact scenarios so you are prepared for what is to come. Let us dive straight into the most lethal financial trap a man faces in a 2026 recession divorce: the weaponization of business valuations. Imagine a man named Michael. Michael spent the past 10 years building a highly profitable regional logistics company. Throughout the previous economic cycle, consumer demand was surging, and his business generated exceptional gross revenue. Based on those specific boom years, a preliminary financial assessment might have valued his company at $4 million. But now we must look at the immediate economic landscape of 2026. Inflation has persistently driven up operating costs, supply chains are heavily constrained, consumer spending has hit a massive contraction, and Michael is actively fighting just to make payroll and keep his employees. His company's true fair market value today might realistically sit at $1.5 million. Then his wife files for divorce. In a standard divorce proceeding involving a business owner, the opposing counsel will immediately hire a forensic accountant to establish the value of Michael's business so that half of its worth can be legally awarded to the spouse. This is exactly where the macroeconomic environment becomes a weapon used against him. The opposing financial expert will deliberately choose an income valuation approach that heavily weighs the historical financial data from the peak revenue years. They will present a highly polished, complex report to the family court judge arguing that the current 2026 economic downturn is merely a temporary market fluctuation, an artificial dip, and that the true intrinsic value of the business remains $4 million. They will aggressively accuse Michael of intentionally deflating his profits simply to avoid paying his fair share in the divorce settlement. Michael is now backed into an impossibly dangerous legal corner. The judge, who is a legal expert but rarely a macroeconomic specialist, looks at the historical tax returns showing massive prior wealth and agrees with the opposing counsel. The court formally values the business at $4 million and orders Michael to pay his wife her 50% equitable share, which equates to $2 million in liquid cash. But Michael does not have $2 million in cash. The business only has $300,000 in operating reserves to survive the ongoing recession. To comply with the court order and avoid being held in contempt, Michael is forced to do the unthinkable. He must either liquidate his operational equipment at fire sale prices in a depressed market, completely destroying his ability to generate future revenue, or he must take out high-interest commercial loans at a time when lending standards are at their absolute tightest and interest rates are crippling. Michael loses the business, he assumes massive debt, and his ex-wife walks away with the remaining liquid capital. This is not a hypothetical nightmare. This is exactly how wealth is systematically transferred and destroyed when a business is appraised using outdated boom market metrics during a live economic contraction. To defend against this outcome, you must aggressively counter their valuation methodology. You cannot rely on a single generalized business appraisal. You must demand that your forensic accountant uses a highly specific, localized market approach that factors in current 2026 industry multiples, heavily discounting the outlier boom years. You must be prepared to introduce expert testimony regarding the specific macroeconomic headwinds facing your exact sector today, proving that the drop in revenue is a systemic market correction, not a voluntary or temporary blip. You must legally establish the difference between active and passive asset depreciation. If your business is losing value because of a national recession, which is a passive macroeconomic factor completely outside of your control, you must argue that you should not be financially penalized for that specific loss in value during the asset division process. Now, imagine an entirely different, but equally devastating scenario involving liquid assets and the terrifying reality of valuation dates. The specific date a family court uses to value your assets can single-handedly dictate whether you survive the divorce or face total financial ruin. Let us look at a case study involving a man named David. David and his wife separate in January of 2025. At the exact time of their legal separation, David has a 401k retirement account invested heavily in index funds, and its total value is $1 million. However, the divorce process is notoriously slow, heavily backlogged, and contentious. The actual trial to finalize the asset division does not happen until 18 months later, in the summer of 2026. During those 18 months, a severe economic contraction hits the United States. The stock market experiences a massive sell-off, and the value of David's 401k plummets from $1 million down to $600,000. In many jurisdictions, the default legal precedent is to value passive assets as of the date of separation, not the date of the actual trial. If the judge applies the date of separation rule, the court views that 401k as being worth $1 million. David is ordered to transfer $500,000, representing his wife's 50% share of the original peak value, through a qualified domestic relations order. Do the math on what just happened. David transfers $500,000 out of an account that currently only holds $600,000. His ex-wife gets $500,000 of preserved wealth, and David is left with exactly $100,000. He just lost nearly 85% of his life savings simply because of the chronological gap between his separation date and the market crash. This exact trap also heavily applies to the marital home. If the real estate market is actively crashing during your divorce proceedings, the equity in your home is vanishing month by month. If your spouse is fighting to keep the house and buy you out of your share, their legal team will intentionally stall the proceedings, waiting for the property value to hit rock bottom before finalizing the appraisal, ensuring they pay you the absolute minimum amount of cash for your half of the equity. Conversely, if you are the one keeping the house and buying her out, her attorneys will aggressively push to use historical appraisals from the absolute peak of the market, forcing you to take out a massive cash-out refinance to pay her for equity that literally no longer exists in the property. You are fighting against a legal clock that is completely out of sync with the economic clock. To protect yourself, your legal team must file immediate motions to establish clear, current valuation dates for every single asset. If you are dealing with highly volatile retirement accounts or stock portfolios, you must legally argue for an in-kind division of the assets, meaning the court divides the actual number of shares equally, rather than assigning a fixed dollar amount based on a past date. If you divide the shares, you both equally share the macroeconomic risk of the recession. If you agree to a fixed dollar payout based on a past valuation, you are absorbing 100% of the market loss entirely by yourself. But asset division is only half of the battlefield. What happens when the recession does not just take your business value or your stock portfolio, but it takes your actual job? What happens when you are a high-earning professional who is suddenly laid off in 2026, and you are staring down a temporary spousal support order that requires you to pay $6,000 a month in alimony that you literally can no longer generate? The courts have a highly punitive, incredibly dangerous mechanism for dealing with unemployed men during a divorce, and if you do not understand exactly how judges view sudden job loss, you will find yourself in a debtor's prison of your own making. The legal mechanism I am referring to is known in family court as imputed income. In a booming economy, the concept of imputed income was originally designed to prevent malicious spouses from intentionally quitting their high-paying jobs to work at a coffee shop just to avoid paying child support and alimony. On paper, this makes logical legal sense. But during a severe macroeconomic contraction, like the systemic shifts we are seeing in 2026, this legal tool becomes a weapon of mass financial destruction against men who are genuine victims of corporate downsizing. The family court system operates on a baseline presumption of historical continuity. Judges look at your past 3 to 5 years of W-2 statements or tax returns, calculate an average, and presume that you are infinitely capable of generating that exact same revenue, regardless of what the Federal Reserve, the stock market, or your specific industry is currently doing. Imagine a man named Christopher. For the past 6 years, Christopher has been a highly successful regional director in commercial real estate lending, earning a base salary and bonuses totaling roughly $220,000 a year. But in 2026, the commercial real estate market experiences a catastrophic liquidity crisis. Office buildings are sitting empty, massive defaults are triggering a chain reaction across regional banks, and Christopher's entire division is completely liquidated. He is handed a severance package and walked out the door on the exact same week. He is served with divorce papers. Christopher does exactly what a responsible father should do. He immediately begins applying for jobs, but nobody in his sector is hiring. In fact, they are all actively firing. To keep the lights on and buy groceries, he takes a massive step backward and accepts a middle management position in retail logistics, making $75,000 a year. When Christopher steps into family court to establish temporary support orders, he assumes the judge will look at his current pay stubs and calculate his alimony and child support obligations based on his new $75,000 reality. This is his fatal error. The opposing counsel will aggressively argue that Christopher is willfully underemployed. They will present his past tax returns and argue that his historical earning capacity is $220,000. They will tell the judge that Christopher took a lower-paying job simply to starve his wife and children out of their rightful standard of living. And in many historical case studies, judges, who are managing overwhelmed dockets and relying on standard legal formulas, will agree with the opposing counsel. The court will legally impute Christopher's income at his old salary. This means the judge signs a binding legal order requiring Christopher to pay $5,000 or $6,000 a month in support, based on a phantom income that no longer exists in the physical world. Christopher only takes home about $4,500 a month after taxes from his new job. His court-ordered obligations now exceed his entire net monthly income. He mathematically cannot comply. He begins to fall behind, accruing what is legally known as arrears. Support arrears are not like regular consumer debt. You cannot discharge them in bankruptcy. They accrue crippling statutory interest rates, sometimes as high as 10% annually depending on the jurisdiction. Once those arrears reach a certain threshold, the state can suspend Christopher's driver's license, revoke his passport, seize his bank accounts, intercept any tax refunds, and ultimately, issue a bench warrant for his arrest under civil contempt of court. This is the modern equivalent of a debtor's prison, entirely manufactured by the court's refusal to acknowledge macroeconomic reality. To defend against the weaponization of imputed income, you must treat your sudden unemployment not just as a personal crisis, but as a complex evidentiary burden. You cannot simply walk into court and say the economy is bad. You must affirmatively prove that your drop in income is involuntary, permanent, and inherently tied to macroeconomic forces outside of your control. This requires retaining a specific professional known as a vocational expert. A vocational expert will conduct a rigorous, highly documented assessment of your skills, your education, and most importantly, the exact state of the 2026 labor market in your specific geographic region and industry. They will produce a comprehensive report proving to the judge that your previous salary is completely unattainable in the current economic climate, and that your new lower-paying job actually represents the absolute maximum earning capacity available to you right now. Furthermore, you must treat your job search like a forensic audit. Judges want to see a flawlessly documented trail of hundreds of job applications, rejection letters, networking emails, and interview logs. You must prove that you are exhausting every single waking hour trying to replace your income, and that the failure to do so is the market's fault, not yours. But what happens if your divorce was already finalized a year ago, and you lose your job today? You are still bound by the original divorce decree. The legal mechanism to fix this is filing a petition for modification of support. However, during an economic recession, the family court system becomes completely gridlocked. Thousands of other people are losing their jobs and filing the exact same modification petitions. Imagine another scenario involving a man named James. James is ordered to pay $3,000 a month in support. He loses his job in March of 2026 due to corporate restructuring. He immediately files a petition to lower his payments. Because the courts are severely backlogged, his actual hearing date is not scheduled until February of the following year. That is an 11-month gap. During those 11 months, James is legally required to continue paying the original $3,000 a month, which he does not have. He falls $25,000 into debt. When he finally gets in front of the judge 11 months later, the judge might agree that he lost his job and lower his future payments. But in many states, the law strictly prohibits the retroactive modification of support arrears. This means the judge legally cannot erase the $25,000 of debt that accumulated while James was waiting for his court date. That debt is permanently vested. James survives the hearing, but he walks out of the courtroom carrying a massive, high-interest anvil around his neck that will take him a decade to pay off. This catastrophic timing trap is precisely why navigating a divorce during a recession requires a preemptive, aggressive legal strategy, rather than a passive, reactive one. You are dealing with an incredibly rigid system that fundamentally punishes economic vulnerability. But as devastating as the income and support battles are, they pale in comparison to the scorched earth tactics deployed when dividing physical assets that are actively depreciating in real time. Imagine being legally trapped in a house you can no longer afford, with an ex-spouse who refuses to sell, while the property value plummets and the mortgage falls into default. The legal strategies used to weaponize the marital home during a recession are some of the most aggressive and financially ruinous tactics in family law. And understanding how to break that deadlock is the only way to save your remaining credit score. The absolute most volatile battleground in a 2026 recession divorce is the marital home. In a standard, booming economic cycle, the marital residence is typically a massive source of liquid equity. The legal process is historically straightforward. The house is appraised, placed on the open market, sold to the highest bidder, the underlying mortgage is paid off, and the remaining profit is split equitably between both parties, allowing everyone to walk away with a cash injection to start their new lives. But when you introduce a severe macroeconomic contraction into this equation, the marital home instantaneously transforms from your greatest financial asset into a highly toxic, wealth-destroying liability. To understand this catastrophic shift, you must first understand the brutal mechanics of an underwater mortgage during a housing market crash. An underwater mortgage occurs when the current fair market value of the property drops below the outstanding principal balance owed to the lending institution. Imagine a case study involving a man named Thomas in the year 2026. Thomas and his wife purchased a beautiful suburban home at the absolute peak of the housing market in late 2023. They bought the property for $600,000, putting down a minimal down payment and securing a massive mortgage. Now the 2026 recession has hit hard. Interest rates have fluctuated wildly, localized housing inventory has skyrocketed due to foreclosures, and buyer demand has completely evaporated. An independent appraisal reveals that the true fair market value of Thomas's home has plummeted to $450,000. However, the outstanding balance on their mortgage is still $550,000. The house is not an asset. It is a legally binding anchor of $100,000 in negative equity. When Thomas and his wife file for divorce, this negative equity creates an immediate, paralyzing legal deadlock. His wife, who may have primary physical custody of their children, vehemently insists on remaining in the marital home to maintain stability for the kids. The family court judge, leaning on historical precedents of maintaining the status quo for children, grant her temporary exclusive use and possession of the property. Thomas is legally ordered to move out and find his own apartment. However, both of their names remain firmly attached to the original mortgage note. This is the exact moment the financial weaponization begins. Thomas is now paying for his own rent, his own utilities, temporary spousal support, and child support. His wife is ordered by the court to pay the monthly mortgage on the marital home using the support money Thomas sends her. But because of the immense financial strain of the 2026 recession, she begins to fall behind. She misses the first mortgage payment. 30 days later, she misses the second. Thomas discovers this not from his ex-wife, but through catastrophic alerts from his credit monitoring services. What men fundamentally fail to realize is that the bank holding the mortgage does not care about your family court orders. The bank is not bound by your divorce decree. The mortgage is a contract of joint and several liability, meaning both parties are 100% responsible for the entire debt. When she misses a payment, Thomas's credit score is instantly decimated, dropping 50 to 100 points in a matter of weeks. The traditional legal advice in this scenario is to force the spouse who is keeping the house to refinance the mortgage solely into their own name, thereby removing the out spouse from the financial liability. But in a 2026 recession, this is often a mathematical impossibility. Lending institutions have drastically tightened their underwriting standards. If Thomas's wife has a lower income, or if her income is primarily composed of temporary alimony, no bank in the country is going to approve her for a $500,000 refinance, especially on a property that is functionally underwater. Therefore, the mortgage remains in Thomas's name, acting as a massive, bleeding wound on his debt-to-income ratio. Even if his ex-wife perfectly pays the mortgage every single month, that massive debt is legally attributed to Thomas. When Thomas tries to go to a bank to get a modest loan to buy a small townhouse for himself, the underwriter looks at his credit report, sees the massive marital mortgage, calculates his debt-to-income ratio at an unapproachable 60%, and flatly denies his application. Thomas is financially paralyzed, completely unable to rebuild his life because he is indefinitely to a depreciating asset he cannot even live in. When a refinance is impossible and the property is actively destroying your credit, the only historical solution is to force a sale of the property, even if it means taking a massive loss or executing a short sale with the bank. The court eventually orders the house to be sold. This is where the tactic of sabotage sales absolutely ruins men in family court. The spouse living in the home realizes that the moment the house is sold, she has to move into a smaller, less desirable rental property. So, she covertly actively sabotages the real estate transaction. When the listing agent schedules an open house, she intentionally leaves the home in a disgusting state. She refuses to accommodate private showings, claiming the kids are sick. When legitimate, market-rate offers actually come in, she refuses to sign the purchase agreement, arguing to the judge that the offers are lowball insults and she wants to wait for the market to recover. She effectively weaponizes the slow, bureaucratic nature of the court system to stall the sale indefinitely. While the house sits rotting on the active market for 8 months, Thomas is forced to continue paying the mortgage to prevent a total foreclosure and the complete destruction of his financial identity. To break this vicious legal deadlock, you cannot rely on passive requests to the judge. You must implement aggressive, highly strategic legal maneuvers designed specifically for distressed real estate in a recession. You must immediately file an emergency motion for the appointment of a real estate receiver. A receiver is an independent, court-appointed professional, often an attorney or a highly specialized real estate broker, who is granted the absolute legal authority to seize control of the property. The receiver has the power to sign listing agreements, accept reasonable offers at fair market value, and physically evict the uncooperative spouse if they continue to interfere with the sale. Paying for a court-appointed receiver is incredibly expensive, often costing tens of thousands of dollars in legal fees, but historical case studies prove it is often the only definitive way to sever the financial anchor before it pulls you completely under. You must view the marital home not as a place of memories, but as a highly dangerous liability that requires immediate liquidation to stop the bleeding. But what happens when the physical assets are finally dealt with, and you turn your attention to your liquid capital? What happens when you look at your bank statements and realize the money you thought you had to survive this recession is already gone? The transition from the battleground of physical real estate to the terrifying, invisible war of financial dissipation and hidden debt is where the most devastating, permanent financial damage occurs. We are now entering the treacherous domain of financial dissipation, a legal term that essentially describes the systematic, often covert, destruction or siphoning of marital wealth leading up to a divorce. In a thriving economy, financial dissipation is a nuisance that is usually remedied by offsetting the stolen funds against the massive equity sitting in the marital home or a booming stock portfolio. However, in the unforgiving landscape of the 2026 U.S. economic recession, liquid cash is the ultimate survival tool. When that cash is secretly drained, there are no bloated assets left to offset the loss. You are simply left with zero. The invisible war of hidden debt and asset dissipation is where historical trends show men suffer the most permanent, unrecoverable financial injuries. To understand the sheer danger of this phase, imagine a scenario involving a man named William. The year is 2026, and William has a highly stressful corporate management position. He senses his marriage is failing, but he is desperately trying to keep his family together while simultaneously navigating massive layoffs at his company. He is distracted, exhausted, and completely focused on macroeconomic survival. His wife, however, has already mentally checked out and is actively consulting with aggressive divorce attorneys. These attorneys, recognizing the severe economic contraction occurring nationwide, advise her to silently prepare her financial exit strategy long before she ever files the actual divorce petition. This triggers a covert operation known in family law circles as cash hoarding. Over an agonizing 6-month period, William's wife begins making consistent, small ATM withdrawals from their joint checking accounts. $200 here, $500 there. She justifies these to William as inflated grocery costs or emergency expenses for the children, things that are incredibly plausible during the 2026 inflation crisis. In reality, she is taking physical cash and placing it into a safe deposit box, or handing it to her sister to hold. Simultaneously, she begins diverting small portions of her own paycheck into an undisclosed, individual bank account located in a completely different financial institution. But the dissipation does not stop at cash. Recognizing that the marital home's equity is evaporating due to the housing crash, she turns to their available lines of credit. She silently maxes out joint credit cards on gift cards, prepaid debit cards, and untraceable luxury goods that can be easily resold later. She pulls $30,000 from their joint home equity line of credit, or HELOC, claiming it is to pay off a high-interest student loan, but instead funnels the capital into a high-yield offshore account. William is completely blind to this systematic drain until the very day he is served with divorce papers. He logs into his primary banking portal to secure funds for a legal retainer, only to discover that the $50,000 emergency liquid safety net he spent a decade building is entirely gone. Instead of a safety net, he is staring at $60,000 in brand new high-interest joint credit card debt. The immediate historical outcome in family court is terrifying. Because William and his wife were legally married when that debt was incurred, the family court presumes it is marital debt, regardless of who physically swiped the credit card. Under the law of equitable distribution or community property, depending on your specific state jurisdiction, William is legally on the hook for half, if not all, of that newly manufactured debt. When William stands before the judge and rightfully claims his wife stole the money and intentionally racked up the credit cards, the burden of proof rests entirely on his shoulders. The court will not simply take his word for it. His wife's legal team will counter-argue that the money was spent on legitimate marital living expenses, survival costs necessitated by the harsh 2026 recession, and paying down community obligations. To combat this incredibly common legal defense, William must pivot from being a passive victim to becoming a financial forensic investigator. He cannot rely on standard discovery requests. He must hire a forensic accountant to perform a granular lifestyle analysis and trace every single missing dollar. This requires issuing aggressive subpoenas to credit card companies, tracking the metadata and IP addresses of digital fund transfers, and demanding the production of records from third-party payment applications. The forensic accountant will meticulously reconstruct the marital estate, creating a legally binding document that proves to the court exactly when the money vanished and where it was diverted. If the forensic accountant successfully proves intentional dissipation, the judge will theoretically perform an action called reconstituting the marital estate. This means the judge takes an imaginary spreadsheet, adds the stolen $50,000 back onto the wife's side of the ledger, and awards William a corresponding credit in the final asset division. But here is the devastating reality of a recession divorce that opposing counsel hopes you do not understand. A judicial credit is only a piece of paper. It is entirely worthless if there are no actual, tangible assets left to satisfy it. In a booming economy, if the wife stole $50,000, the judge would simply award William an extra $50,000 from the equity of the house sale. But in our 2026 scenario, the housing market has crashed, and the home is underwater. The stock portfolio has been decimated by the bear market. The business valuation is in the gutter. There are absolutely no remaining liquid assets to offset the credit against. The judge can award William $1 million judgment for dissipation, but he cannot collect it because his ex-wife has successfully hidden the cash, and the marital estate is entirely bankrupt. William is left holding a hollow legal victory, while actively defaulting on the joint debt she left behind. Furthermore, you must understand the critical vulnerability window before the automatic temporary restraining order goes into effect. In many jurisdictions, when a divorce petition is formally filed and served, an automatic financial injunction is placed on both parties. This legal mechanism strictly forbids the selling, transferring, or hiding of any marital assets. However, this injunction only applies after the paperwork is filed. The most severe financial bleeding historically occurs in the 12 to 18 months prior to the filing date, a period when one spouse is actively planning the divorce while the other is completely unaware. If you suspect your marriage is failing during an economic downturn, you must immediately secure your own credit profile, freeze joint lines of credit before they can be weaponized, and legally separate your direct deposits to prevent a total wipeout of your operating capital. You must view every joint account not as a shared resource, but as a potential liability that can be legally emptied without your consent. Surviving the invisible war of financial dissipation requires extreme vigilance, preemptive defensive measures, and the willingness to audit your own life before the court does it for you. But what happens when the liquid cash is gone? The physical real estate is a toxic liability, and you turn your attention to the only assets you have left. The assets you have worked your entire adult life to secure for your old age. We must now transition from the battleground of present day cash to the terrifying legal arena of future wealth. What happens when the court system targets your protected pensions, your highly complex executive deferred compensation packages, and your unvested stock options? The legal mechanisms used to strip away decades of future security during a recession are some of the most complex and permanently damaging forces in family law. The legal mechanisms used to strip away decades of future security during a recession are some of the most complex and permanently damaging forces in family law. We are now entering the highly technical, unforgiving realm of deferred compensation, retirement accounts, and unvested stock options. The greatest misconception men hold when entering a divorce is that the funds sitting in their individual 401k, their private IRA, or their company pension are somehow insulated from the division of assets because only their name is on the statement. In the eyes of the family court system, any wealth generated, contributed, or vested from the exact date of your marriage up to the date of separation is considered community property or part of the equitable distribution pool. During a booming economy, dividing these accounts is a painful but predictable mathematical exercise. But in the volatile, highly destructive market conditions of the 2026 economic recession, dividing future wealth becomes a lethal game of shifting massive macroeconomic risk entirely onto your shoulders. To comprehend the sheer danger, you must first understand the specific legal instrument used to divide retirement accounts, known as a Qualified Domestic Relations Order, or QDRO. A QDRO is a highly specialized court order that instructs a retirement plan administrator to legally siphon a specific portion of your retirement funds and transfer them to an alternate payee, which is your ex-wife. The trap lies in exactly how that QDRO is written during a bear market. Let us look at a terrifying historical trend involving a man named Daniel. Daniel and his wife legally separate in January. At that exact moment, Daniel has a 401k worth $800,000. They agree in mediation that his wife is entitled to a 50% share of the marital portion, which amounts to exactly $400,000. The lawyers draft the QDRO specifying a fixed dollar amount payout of $400,000 to the ex-wife. However, drafting, signing, and executing a QDRO takes months. During that massive administrative delay, the 2026 recession hits the stock market with absolute fury. By the time the plan administrator finally processes the QDRO in October, the total value of Daniel's 401k has collapsed from $800,000 down to $500,000. Because Daniel's legal team allowed the QDRO to be written as a fixed dollar amount rather than a percentage of shares, the plan administrator legally must transfer the exact $400,000 to his ex-wife. Daniel is left with a devastating $100,000. He absorbed 100% of the recession market loss, while his ex-wife walked away with absolute, guaranteed capital preservation. To prevent this financial wipeout, your legal strategy must mandate that any division of market-dependent assets is calculated strictly as a percentage of the total shares in kind, meaning if the market drops 30%, both parties equally share the sting of that macroeconomic reality. But the battlefield becomes exponentially more treacherous when we examine executive compensation, specifically restricted stock units and unvested stock options. Imagine a man named Robert working in the 2026 tech sector. Robert receives a massive portion of his annual compensation in the form of company stock options that vest over a 4-year schedule. When Robert files for divorce, opposing counsel does not just look at the shares he already owns. They aggressively target the shares he has not even earned yet. To divide unvested stock, family courts utilize a complex mathematical formula known as the coverture fraction. This formula essentially calculates how much of the unvested stock was theoretically earned during the marriage versus how much is strictly related to future, post-divorce labor. The 2026 recession weaponizes this formula against the primary earner. Opposing counsel will bring in financial experts to argue that the unvested stock was granted entirely as a reward for past performance during the marriage, thereby maximizing the wife's legal claim to those future shares. Now, combine this legal ruling with the reality of corporate layoffs. If Robert is ordered to pay out the equivalent future value of those unvested shares, but he is suddenly laid off 3 months later due to corporate downsizing, those unvested shares instantly evaporate. The company cancels them. Yet, depending on how the final divorce decree was meticulously worded, Robert might still be legally obligated to pay his ex-wife the cash equivalent of those phantom shares based on their valuation on the date of the divorce. He is forced to pay real, liquid cash out of his own pocket for stock options that literally vanished into thin air. You must ensure your legal counsel drafts explicit safeguard clauses that explicitly tie any payout of unvested assets to their actual realization. If the shares do not vest because of a recession-induced layoff, your financial obligation must legally terminate simultaneously. Finally, we must dissect the ultimate time bomb of future wealth division: the defined benefit pension plan. If you are a police officer, a firefighter, a teacher, or a long-term corporate employee with a traditional pension, your retirement is based on a future monthly payout until you die. During a divorce, the opposing counsel will often demand a present value cash buyout of that future pension. They want you to give up liquid assets today in exchange for keeping your full pension tomorrow. To determine how much cash that pension is worth today, forensic accountants use a critical metric called the discount rate. During a recession, interest rates and inflation metrics are highly erratic. If the opposing financial expert successfully argues for a low discount rate, it artificially inflates the present value of your pension to astronomical levels. A pension that might actually be worth $300,000 today is suddenly valued at $600,000 on the court spreadsheet. You are then ordered to hand over $300,000 in actual, liquid cash or give up all the equity in the marital home just to buy out your wife's share of a pension that you might not even live long enough to collect. This is how men are systematically stripped of their current liquidity in exchange for future promises that may never materialize. You are trading hard survival capital in the middle of an economic crisis for a retirement asset that is decades away. You must treat the division of future wealth not as an afterthought, but as the single most complex financial transaction of your entire life. You must employ specialized actuaries to fight over every single decimal point in a pension valuation. You must demand the exact tracing of premarital funds to ensure you are not giving away money you saved long before you ever met your spouse. But as you exhaust your resources fighting over forensic accounting, stock options, and pension valuations, an entirely different, incredibly vicious legal war is brewing. What happens when the dispute shifts from the division of your financial portfolio to the absolute most precious asset of all? The legal weaponization of child custody during a severe economic downturn introduces a terrifying dynamic where children are effectively transformed into localized leverage points. When a mother loses her job in a recession and cannot afford to live in the expensive marital jurisdiction, the family court is faced with the ultimate, highly destructive question of parental relocation. How do you defend your right to be a father when the opposing counsel uses the collapsing economy as the ultimate legal justification to move your children across the country? The legal battle over parental relocation, formerly known in family court as a move-away case, is historically one of the most agonizing, high-stakes conflicts in the entire judicial system. In a period of economic stability, these cases are exceedingly difficult for the petitioning spouse to win. Judges fundamentally prefer to keep both parents in close geographic proximity to the children to maintain a consistent environment. But the 2026 recession violently disrupts this judicial preference. When the macroeconomic environment collapses, the opposing counsel gains a highly persuasive, highly destructive legal argument, the argument of sheer financial survival. They weaponize the collapsing economy to convince a family court judge that taking your children across the country is not an act of alienation, but an absolute biological and economic necessity. Imagine a highly realistic 2026 scenario involving a father named Richard. Richard and his ex-wife live in a high-cost-of-living metropolitan area, perhaps somewhere in Southern California or the Northeast. They currently share a 50-50 joint physical custody arrangement. Both are actively involved in the daily lives of their children, attending school events, coaching sports, and maintaining a deep physical bond. Then the recession strikes. Richard's ex-wife is unexpectedly laid off from her mid-level corporate job. She exhausts her severance package. Her lease is up for renewal, and her corporate landlord is raising the rent by 20% to keep pace with localized inflation. She is mathematically drowning in debt. So her legal team files an emergency petition for parental relocation. The petition formally asks the judge for legal permission to move the children 2,000 miles away to a much lower cost of living state, let us say Ohio or Texas, where she can live completely rent-free in her parents' house and take advantage of an allegedly more favorable local job market. Richard is suddenly thrust into a living nightmare. He is no longer just fighting over money. He is fighting for his fundamental right to see his children more than just a few weeks in the summer. The judge evaluating this petition is forced to weigh two competing interests under the overarching legal doctrine, known as the best interest of the child standard. On one side is Richard's fundamental right to maintain a consistent, physical, day-to-day relationship with his children. On the other side is the mother's undeniable, extensively documented economic crisis. Historically, during severe economic downturns, courts have shown an alarming propensity to prioritize financial stability, food security, and housing infrastructure over the geographic proximity of the father. If the mother can categorically prove that she is facing imminent homelessness in the current jurisdiction and has a guaranteed, stable safety net in another state, the judge may legally sanction the relocation. If this relocation is granted, the cascading financial and emotional devastation on Richard is absolute. He instantly devolves from a 50-50, day-to-day father into a long-distance virtual parent restricted to video calls and text messages. But the economic punishment does not stop there. The family court will draft a long-distance parenting plan. Richard will be granted visitation during summer breaks, alternating holidays, and perhaps one weekend a month if he can afford to travel. However, the court historically places the overwhelming financial burden of executing this long-distance visitation squarely onto the father's shoulders. Richard is now legally responsible for purchasing last-minute, highly inflated airline tickets for his children during peak holiday seasons. He must pay for expensive hotel rooms, rental cars, and massive amounts of lost wages for the time he has to take off work to physically facilitate the travel. Because he is already being severely financially squeezed by the 2026 recession, these astronomical travel costs quickly become completely prohibitive. Within a single calendar year, Richard finds himself financially incapable of exercising his court-ordered visitation rights. The geographical distance, born entirely out of an economic crisis, effectively achieves complete parental alienation without the mother ever having to violate a single court order. To successfully defend against a recession-based relocation petition, you cannot simply argue that you love your children and want them to stay. Emotional pleas are completely useless against forensic economic data in a courtroom. You must mount a highly sophisticated, data-driven counteroffensive that completely dismantles her claim of absolute financial necessity. Your legal team must hire specialized vocational experts to prove that the mother has completely failed to exhaust all localized employment opportunities. These experts will conduct a granular labor market survey. You must present the judge with a massive documented dossier of hundreds of available jobs in your current city that match her exact skill set and historical earning capacity. You must legally demonstrate that her desire to move is not based on sheer survival, but is actually a strategic, bad faith maneuver to separate you from your children under the highly convenient guise of an economic crisis. Furthermore, if her financial hardship is genuinely legitimate, you may have to make agonizing, strategic financial sacrifices to defeat the relocation. This might involve temporarily offering a highly specific, legally binding housing subsidy out of your own pocket. You might have to present a comprehensive financial plan to the judge where you formally agree to absorb a significantly larger percentage of the children's localized living expenses, strictly conditioned upon the children remaining in the current geographic jurisdiction. This is effectively a brutal financial extortion, forcing you to pay an artificial premium just to maintain basic physical access to your own children. But in the cold, mathematical calculus of family court during a recession, keeping your children close often requires bleeding your own highly depleted liquid assets completely dry. But we must also deeply examine the terrifying inverse of this scenario. What happens when the recession directly impacts your housing stability? Imagine you are the one who is suddenly laid off in 2026. You quickly exhaust your emergency savings, and you are forced to move out of your comfortable two-bedroom apartment into a much smaller, highly cramped studio. Or perhaps you are forced to rent a single room in a shared house just to survive the brutal economic contraction. The opposing counsel will instantly weaponize your economic victimhood against your custody rights. They will file an aggressive emergency motion to modify the existing custody arrangement, arguing to the judge that your new, highly diminished living situation is entirely unsuitable for the children. They will claim you no longer have adequate dedicated space, that the new neighborhood is statistically unsafe, or that your ongoing financial instability creates severe psychological stress for the kids. The family court system historically punishes poverty with terrifying efficiency. Even if your financial downfall is entirely the direct result of a macroeconomic collapse completely outside of your control, the judge will heavily scrutinize your current living conditions. If you cannot provide a dedicated, private bedroom for your children, the court may drastically reduce your physical custody time, stripping away your overnight visits entirely and reducing you to a few hours of supervised public dinner visits a week. You are being legally and emotionally penalized for your inability to out-earn a historic national recession. To survive this brutal attack, your legal defense must aggressively separate your financial status from your parental fitness. You must provide undeniable psychological evaluations and expert testimony proving that the children absolutely thrive in your care, regardless of the square footage of your current apartment. You must legally establish that a temporary economic setback does not magically erase your capacity to be a highly effective, deeply loving father. Defending your right to parent your children during an economic collapse is an all-consuming, emotionally harrowing, and financially exhausting battle. It requires an absolute avalanche of documentation, highly paid expert testimony, and relentless legal maneuvering. But as you fight tooth and nail to protect your business valuations, your underwater mortgage, your future retirement, and your absolute fundamental right to be a father, you are actively burning through the single most critical resource in any legal conflict. You are burning through your liquid cash. And this introduces the most terrifying systemic trap purposely designed by the family court system. What happens when the massive legal fees completely bleed you dry? What happens when you are mathematically bankrupt, but the court issues a devastating order forcing you to pay for the exact opposing attorney who is actively trying to destroy your life? The chilling reality of attorney fees shifting during a recession is a mechanism of total financial annihilation. The chilling reality of attorney fees shifting during a recession is a mechanism of total financial annihilation. Let us examine the exact legal statutes that make this nightmare possible. In family court, there is a foundational legal doctrine designed to create a supposedly equitable playing field between divorcing spouses. This concept is built on the premise of need and ability to pay. If one spouse has historically been the primary breadwinner, and the other spouse has significantly less income or has been out of the workforce, the court possesses the absolute statutory authority to order the higher-earning spouse to pay the legal fees of the lower-earning spouse. In a booming, highly liquid economy, this fee shifting is often viewed as a painful but manageable wealth transfer. But in the brutal, cash-starved reality of the 2026 United States economic recession, this legal mechanism transforms into a weapon of mass financial destruction that forces a man to literally fund his own demise. Imagine a case study involving a man named Charles. Charles spent the last decade building a career as a senior software engineering manager. During the peak economic years, his compensation package was highly lucrative. However, The 2026 recession has absolutely devastated the technology sector. Charles is caught in a massive wave of corporate layoffs. His income drops to zero overnight, and he is forced to survive on a rapidly depleting severance package and whatever liquid savings he has left while desperately searching for employment in a frozen labor market. His wife, who has not worked in the corporate sector for 7 years, files for divorce. She retains an aggressive, high-priced boutique family law firm. Immediately upon filing, her legal team submits a pendant light motion for attorney fees. Pendant light is a Latin legal term meaning pending the litigation. They are asking the family court judge to force Charles to pay a $50,000 upfront retainer to their law firm so they can aggressively litigate against him. When Charles walks into the courtroom for the temporary hearings, he expects the judge to look at his current unemployment status and deny the motion. This is a fatal misunderstanding of how the system processes historical data. The opposing counsel will present Charles's W-2 statements from 2023 and 2024, highlighting his past massive earning capacity. They will argue to the judge that Charles is fully capable of paying these fees, and that his current unemployment is merely a temporary setback. The judge, relying on the immense historical disparity in their incomes, grants the motion. The court issues a legally binding order compelling Charles to transfer $50,000 in liquid cash to his wife's attorney within 30 days. Examine the catastrophic mathematics of this exact moment. Charles does not just have to find $50,000 for his wife's lawyer. He also has to pay his own legal counsel to defend him. He needs $100,000 in highly liquid capital instantly. Because he is unemployed and credit markets are frozen due to the recession, he cannot secure a personal loan. He is forced to turn to his only remaining asset, his retirement portfolio. He liquidates $150,000 from his 401k. However, because he is under the standard retirement age, he is hit with a massive early withdrawal penalty, plus federal and state income taxes on the distribution. He drains a massive portion of his life savings just to generate the net cash required to comply with the court order. He has effectively cannibalized his own future survival just to pay the person who is actively trying to destroy his present reality. But the nightmare of fee shifting does not end with the initial retainer. It creates a highly toxic, deeply corrupting incentive structure known as the blank check phenomenon. In a standard legal dispute, both parties perform a cost-benefit analysis before filing motions. They ask themselves if fighting over a certain asset is truly worth the hourly attorney fees. But when the family court orders Charles to pay his wife's legal bills, her attorneys suddenly have zero financial incentive to settle the case efficiently. They are operating with a blank check, and Charles's remaining net worth is the bank account. Opposing counsel will intentionally weaponize the discovery process to generate maximum billable hours. They will issue exhausting multi-page demands for every single bank statement, credit card receipt, and text message from the last 5 years. They will schedule multi-day depositions for Charles, knowing that for every hour they sit in that conference room, Charles is legally obligated to pay their astronomical hourly rate, while simultaneously paying his own lawyer to sit right next to him. This is a deliberate strategy of financial exhaustion. It is a war of attrition designed to bleed the primary earner completely dry so that he capitulates to an entirely unfair settlement agreement simply because he can no longer afford the daily cost of fighting. If Charles attempts to propose a highly reasonable, mathematically fair settlement based on the 2026 recession reality, the opposing counsel will routinely advise his wife to reject it. They will claim he is hiding assets and that they need to conduct further, highly expensive forensic investigations. They use the legal system as an endless revenue generator, entirely shielded from the economic consequences of their own aggressive litigation tactics. To defend against this systematic financial draining, you must aggressively attack the baseline assumptions of the fee-shifting request. You cannot just stand before the judge and plead poverty. You must present an incredibly detailed, rigorously documented case information statement or financial affidavit that undeniably proves your absolute lack of liquidity in the current 2026 economic climate. You must demand an evidentiary hearing strictly focused on your real-time, present-day inability to pay, aggressively countering their reliance on outdated historical tax returns. Furthermore, your legal team must file highly strategic motions to cap the opposing counsel's fees, legally arguing that their exhaustive discovery requests are not designed to uncover facts, but are strictly overly broad, bad faith maneuvers designed solely to harass and bankrupt you. You must also be prepared to fight the insidious imputation of family wealth. In historical case studies during severe recessions, When a man truly runs out of money to pay the opposing attorney, the opposing counsel will often argue that the man has access to capital through his extended family. They will tell the judge that Charles's elderly parents own a valuable home, and that he could easily borrow money from them to fund the litigation. You must be prepared to legally establish an absolute firewall between your marital estate and your extended family's assets, proving that you have no legal right or ability to compel third parties to finance your divorce. When the financial exhaustion strategy reaches its breaking point, a terrifying reality sets in. Charles completely runs out of money. Because he can no longer pay his own lawyer, his legal counsel is forced to formally withdraw from the case. But the wife's lawyer is fully funded by the court's initial fee-shifting orders and the liquidation of the marital assets. Charles is now forced to represent himself pro se against a highly trained, fully funded legal assassin in a complex high-stakes trial. He is completely outmatched, systematically stripped of his defenses by the very court system designed to ensure equity. But financial exhaustion is merely the precursor to the final, most devastating tactic deployed in a high-conflict recession divorce. When the liquid cash is completely gone, and the opposing side desires absolute, uncontested control over the remaining physical assets and total, unilateral custody of the children, they deploy the nuclear option of family law. What happens when you wake up to law enforcement officers at your front door, serving you with a temporary restraining order based on entirely fabricated allegations, instantly evicting you from your own home and stripping you of all parental rights before you even have a single opportunity to speak to a judge and defend yourself? The legal maneuver is formally known as an ex parte temporary restraining order, and it is the absolute nuclear option in high-conflict family law. In legal terminology, the Latin phrase ex parte means from one party. It signifies a judicial proceeding where only one side is present, and the opposing party is given completely zero notice that the hearing is even taking place. In a standard, ethical legal dispute, both sides have the right to be heard before a judge issues an order that alters their lives. But the family court system has carved out a massive, highly controversial exception for allegations of domestic violence. If a spouse walks into a courthouse and files a sworn affidavit claiming she is in imminent fear for her physical safety, a judge will almost always sign the temporary restraining order immediately. The court operates on a doctrine of extreme risk aversion. No judge wants to be the one who denied a protective order only to have a tragedy occur the very next day. Therefore, they rubber stamp these temporary orders based entirely on unverified, one-sided allegations, planning to sort out the actual truth at a full evidentiary hearing several weeks later. During a booming economy, false restraining orders are often used as a dirty tactic to gain the upper hand in custody negotiations. But in the incredibly harsh environment of the 2026 economic recession, this tactic is systematically weaponized for raw, immediate financial survival. Imagine a case study involving a man named Mark. Mark and his wife are drowning in recession-induced debt. Their marital home is actively facing foreclosure. Their credit cards are entirely maxed out, and the daily stress in the household is palpable. Mark is desperately trying to negotiate a short sale of the property to save them both from bankruptcy. His wife, however, refuses to leave the house. She consults with an aggressive legal team who advises her that a standard eviction or forced sale could take a year in the backlogged civil courts. They suggest a much faster, highly destructive alternative to gain absolute control of the physical asset. Following a heated but entirely non-violent verbal argument about paying the electricity bill, Mark leaves for work. While he is gone, his wife drives to the courthouse. She files an ex parte petition claiming that Mark was yelling, that he slammed a door, and that his erratic financial stress makes her fear for her life. She does not need to show bruises. She does not need an independent witness. Her sworn statement of subjective fear is the only legal threshold required. The judge signs the order. Later that evening, as Mark sits in his living room trying to balance his depleted checking account, heavily armed law enforcement officers knock on his door. They serve him with a legally binding document that instantly strips him of his fundamental constitutional rights. He is given exactly 10 minutes to pack a single bag of clothing. He is forcibly escorted off his own property under the threat of immediate arrest. The financial and logistical devastation of this single moment in a recession is absolute. Mark is suddenly homeless on a Tuesday night. In a healthy economy, a professional man might simply check into an extended stay hotel or rent a furnished apartment while his lawyers sort out the mess. But this is 2026. Mark has no liquid capital. His credit is paralyzed. When he tries to apply for a short-term lease, The landlord runs a background check, sees an active restraining order in the public database, and instantly denies the application due to liability concerns. Mark is forced into predatory, exorbitant nightly motels or is relegated to sleeping in his vehicle. Meanwhile, he remains legally and financially responsible for paying the mortgage, the property taxes, and the utilities on the marital home. He is now criminally forbidden from entering. The opposing counsel has successfully weaponized the state apparatus to secure exclusive use and possession of the most valuable physical asset, entirely bypassing the normal, equitable division process. But the weaponization extends far beyond real estate. The ex parte order automatically grants the mother 100% temporary sole physical and legal custody of the children. Mark is strictly prohibited from calling, texting, or coming within 500 feet of his own kids. If he accidentally runs into them at the local grocery store and simply says hello, his wife can call the police, and Mark will be arrested and charged with a criminal felony for violating a protective order. This creates a terrifying legal vacuum. During the 2026 recession, family courts are operating with massive budget deficits and unprecedented caseloads. The mandatory evidentiary hearing, which is supposed to happen within 2 weeks, is heavily delayed by the overloaded judicial docket. Mark goes 3 entire months without seeing his children. By the time he finally gets his day in court to prove the allegations were completely fabricated, the psychological damage is already done. The opposing counsel will stand before the judge and pivot their argument. They will argue that the children have now established a new stable routine without their father over the past 90 days. They will invoke the highly dangerous legal concept of maintaining the status quo. They will argue that disrupting this newly established routine by reintroducing Mark into their lives would be highly detrimental to the children's psychological well-being amidst the broader economic crisis. The temporary, fraudulently obtained custody arrangement slowly hardens into a permanent legal reality, completely erasing Mark as a custodial parent based on an initial lie. Furthermore, you must deeply understand the secondary catastrophic impact of a temporary restraining order on your absolute ability to survive the recession. The modern 2026 labor market is incredibly fragile. Employers are looking for any excuse to trim headcount. If you work in finance, education, healthcare, or any corporate sector requiring security clearances or strict ethical compliance, an active restraining order on your public record can trigger an immediate suspension or outright termination. Your employer does not care about the nuances of family court disputes. They only care about mitigating their corporate liability. You are fighting to prove your innocence while simultaneously losing the exact income you desperately need to pay your legal defense team. To survive this completely asymmetrical warfare, your response must be radically disciplined and heavily rooted in digital forensics. The absolute most common mistake men make when served with a false restraining order is attempting to contact their spouse to demand an explanation or negotiate a truce. You must understand that every single text message, email, or voicemail you send is a literal gift to the opposing counsel. They will take your desperate attempt at communication, print it out, and present it to the judge as undeniable proof that you are an obsessive, boundary-violating threat who refuses to respect court orders. You must enforce an absolute, total blackout of all communication. Instead of reacting emotionally, you must immediately retain highly specialized legal counsel who understands how to cross-examine false allegations using hard, empirical data. You must gather every single piece of digital evidence from the weeks leading up to the ex parte order. You need Ring camera footage proving you left the house peacefully. You need GPS tracking data from your smartphone demonstrating you were miles away when the alleged incident occurred. You need to present the judge with an extensive audit of text messages and emails proving that the only actual conflict in the marriage was strictly related to the underwater mortgage and the 2026 financial crisis, completely isolating the dispute to civil economics rather than criminal violence. You must legally expose the strategic, financially motivated timeline of the filing. Fighting a fabricated restraining order is the ultimate test of your endurance, your legal strategy, and your rapidly diminishing financial resources. You are forced to defend your liberty, your property, and your children all at exactly the same time, in front of a judicial system that is inherently biased toward believing the initial allegations. But what happens when the final gavel falls? What happens when the assets are finally liquidated, the massive legal debts are codified, and you are left standing in the ashes of your former life, staring down the barrel of a historical economic depression with absolutely nothing to your name? How do you reconstruct an entire existence from absolute mathematical zero, when the broader economy is actively working against your recovery. The psychological and financial blueprint for surviving the immediate aftermath of a recession divorce is the final, most critical phase of this entire ordeal. The psychological and financial blueprint for surviving the immediate aftermath of a recession divorce is the final, most critical phase of this entire ordeal. The gavel has officially fallen. The ink on the final decree is dry. The adrenaline of the multi-year litigation war instantly evaporates, leaving behind a crushing silent reality. You are standing in the epicenter of your own completely reconstructed life, surrounded by the macroeconomic debris of the 2026 recession. The historical trends of post-divorce recovery indicate that the first 12 to 18 months are where men either lay the impenetrable foundation for a massive financial comeback, or they succumb to the overwhelming mathematical weight of their new reality and fall into permanent, unrecoverable ruin. Imagine a man named Steven. Steven has just finalized his divorce in November of 2026. He lost the marital home, his retirement accounts were severely halved during a massive stock market contraction, and he is now legally burdened with a high monthly spousal support payment. He is sitting in a cramped, incredibly expensive one-bedroom apartment because localized rent inflation has completely outpaced wage growth. Steven is staring at a spreadsheet that mathematically dictates his survival. His monthly net income barely covers his basic living expenses after the court-ordered garnishments. The most dangerous trap Steven faces in this exact moment is the psychological refusal to accept his new baseline. Many men historically attempt to maintain the illusion of their pre-divorce, pre-recession lifestyle. They finance vehicles they can no longer afford. They take on massive amounts of unsecured consumer debt to furnish their new apartments, and they attempt to buy their children's affection with expensive vacations they fundamentally cannot cash flow. This is a recipe for absolute systemic collapse. To survive this immediate aftermath, you must execute a strategy of radical, ruthless financial triage. You must strip your life down to the absolute bare structural minimums. This means completely divorcing your ego from your living situation. If historical case studies of the 2008 Great Recession teach us anything, it is that those who survived the wealth wipeout did so by immediately accepting a temporary reduction in their perceived social status. You must meticulously audit every single outgoing dollar. You are no longer investing for early retirement. You are strictly managing a wartime operating budget designed to build a highly liquid emergency fortress. The absolute most treacherous hazard in this post-divorce landscape is the lingering shadow of joint marital debt. In your final divorce decree, the family court judge likely assigns specific debts to your ex-spouse. The court order might explicitly state that she is 100% legally responsible for paying off a massive joint credit card balance. The catastrophic misunderstanding that destroys men is the belief that this court order physically removes their legal liability with the actual lending institution. It absolutely does not. The credit card company was never a party to your divorce. If your ex-spouse loses her job in the ongoing 2026 recession and defaults on that joint card, the bank will immediately pursue you for the entire balance, and your personal credit score will be instantly decimated. To defend your newly separated financial identity, you must operate with aggressive, daily vigilance. You must place comprehensive security freezes on all major credit bureaus to prevent any new lines of credit from being fraudulently opened. You must utilize advanced credit monitoring services to track the exact payment history of every single joint account your ex-spouse was ordered to pay. If you see a payment is 30 days late, you are faced with a brutal tactical decision. Historical outcomes show that men who step in and make the minimum payment themselves out of their own depleted pockets are the ones who successfully protect their credit scores. You are essentially paying an extortion fee to shield your financial reputation from her economic instability. You can technically take her back to family court later to enforce the decree and ask the judge to hold her in contempt for missing the payment, but the family court cannot magically repair the catastrophic damage done to your FICO score. Your credit profile is your absolute lifeline for securing future housing and future employment in a highly depressed economy. You must protect it with ruthless efficiency. For many men, the sheer volume of the accumulated marital debt, combined with the crushing weight of ongoing spousal support and the broader economic contraction, creates a mathematical impossibility. When your debt-to-income ratio exceeds your absolute physical capacity to generate revenue, you must objectively evaluate the strategic implementation of federal bankruptcy protection. Society attaches a massive, debilitating stigma to bankruptcy, framing it as an ultimate moral failure. But in the cold, empirical reality of a recession divorce, financial professionals often view bankruptcy not as a failure, but as a legally sanctioned, highly calculated business reorganization. If you are drowning in $50,000 of unsecured marital debt that you were forced to absorb, a Chapter 7 liquidation or a Chapter 13 reorganization might be the only mathematical path to breathing room. However, you must profoundly understand the legal limitations. Bankruptcy laws in the United States strictly dictate that you can never discharge domestic support obligations. You cannot wipe away child support, and you cannot discharge alimony. Those debts are permanently vested. But by systematically discharging the suffocating consumer debt, you free up the critical monthly cash flow necessary to actually pay your support orders and avoid being thrown into civil contempt of court. Navigating this requires retaining highly specialized bankruptcy counsel, who deeply understands the complex intersection of federal bankruptcy code and state family law, ensuring you do not accidentally trigger a devastating legal crossfire. Beyond the raw mathematics, we must comprehensively address the silent, highly lethal psychological toll of the post-divorce recession environment. The historical data regarding the mental health of divorced men facing sudden economic ruin is absolutely staggering. The systemic isolation, the loss of daily contact with children, the destruction of identity tied to the role of a primary provider, and the sheer exhaustion of navigating a hostile legal system create a highly dangerous psychological vacuum. You will wake up in a quiet, unfamiliar apartment, staring at a bank account that has been completely reset to zero, and the sheer gravity of the rebuild will feel entirely insurmountable. This is exactly where you must engineer a deliberate, highly structured mental operating system. You cannot rely on spontaneous motivation. You must rely on rigid, unbreakable daily discipline. You must immediately construct a new micro-community. The family court system thrives on isolating men, making them feel as though their exact suffering is an anomaly. It is not. Millions of men are actively navigating this exact same macroeconomic meat grinder in 2026. You must seek out highly focused support networks, localized groups of men who are actively focused on wealth reconstruction and legal resilience, rather than simply dwelling on the perceived unfairness of the family court system. You must transform your living space, no matter how small or austere, into a highly disciplined base of operations entirely focused on your physical health, your ongoing legal strategy, and your aggressive career rehabilitation. When it comes to your children, you must completely rewrite the paradigm of how you parent. During a recession, you can no longer rely on capital to facilitate connection. You cannot take them to expensive theme parks or buy them massive quantities of consumer goods to compensate for your physical absence. You must actively teach them the profound value of resilience through your own daily actions. Historical case studies of children who successfully navigate their parents' divorce during severe economic downturn show that they do not remember the square footage of their father's apartment. They remember his emotional stability, his unwavering consistency, and his absolute refusal to quit when the entire world was actively collapsing around him. You transition from being a provider of luxury to becoming a fundamental anchor of psychological safety. You build connection through highly intentional, low-cost, high-value time. You teach them how to cook basic meals, you read with them, you focus entirely on their psychological development rather than their material consumption. The 2026 economic recession will inevitably expose every single structural flaw in the family court system, and it will exact a brutal, unprecedented toll on the men forced to navigate its machinery. But absolute financial ruin is not a permanent destination. It is a brutal, highly educational transition period. By aggressively protecting your remaining capital, strictly defining your new legal boundaries, managing your post-divorce debt with forensic precision, and rebuilding your psychological architecture from the ground up, you can execute a historical comeback. The legal war for your past assets is officially over. The strategic war for your future generational wealth begins exactly right now. But what happens when the broader economy begins to slowly shift, and new, highly volatile asset classes emerge as the ultimate tools for wealth reconstruction? How do you leverage the changing financial tides to completely rebuild your empire faster than the family court system ever thought possible?